We are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Duran and Duran Schultz Law.
Hi! Welcome to Legally Sis. I'm Attorney Wen.
And I'm Attorney March. Welcome to our podcast.
So for today's episode, we will be discussing about co-ownership and how to end co-ownership.
This is a situation when there are multiple parties or multiple owners for one particular property.
Yes.
So, Attorney Wendy, what is co-ownership?
Co-ownership, this is a situation whereby there is an undivided property which is owned by different persons.
Okay, if you are a co-owner to a particular property, how do you subdivide it?
You can subdivide a particular property through partition.
Okay. Is it by mere documentation, a deed?
So it depends. So under the rules of court, we have different situation for partition. It could either be a judicial partition or an extrajudicial partition. When you say extrajudicial partition, this is whereby the co-owners will have to agree among themselves through a partition agreement, subdividing the undivided property among themselves.
And the other type would be judicial, which means you are forced to go to court to have the particular property subdivided among the co-owners.
Yes.
So could you please give us examples as to when there is co-ownership?
Co-ownership could either be formed through contracts, which could be through deed of sale or donation or assignment. And another one is through intestate succession or through wills.
Okay. Or even corporate dissolution. The corporation would have property and then the shareholders would be the forced co-owners of the asset of the dissolved corporation. But going back to the creation of a co-ownership via sale and donation. So this happens when, for example, as siblings, we would buy a condominium that we will be co-owning. Then that would mean we voluntarily entered into a contract and wanted that both of us would be indicated in the title.
Yes, or in a situation wherein you, for example, you're married and you and your husband would buy a property and then both of your names will be indicated in that title.
Yeah. How about for extrajudicial settlement of estate? When you are heirs, there is also a situation that the property, when extrajudicially indicated, there is also a situation wherein through the extrajudicial settlement, all of the heirs are co-owners of a particular property.
Yes, that's where the intestate succession comes in.
So if you find yourself a co-owner to a property and the parties, the co-owners, are willing to subdivide extrajudicially or voluntarily, what do you need to do?
For that kind of situation, the parties will have to draft a partition agreement and detailing there the descriptive property or the particular property that they wanted to partition. And then they also need a subdivision plan, which will be drafted by a licensed geodetic engineer. So he will be responsible for surveying the land and creating a new technical description over that land.
Just to clarify, the subdivision plan is not the subdivision that you're living in.
Oh yeah, yes. That's
It's
different.
it's a plan done or drafted by a geodetic engineer having done the survey of the lot so that you can identify the means and bounds.
Yes, and also you will need a survey plan also. This document will have to be submitted before the Land Registration Authority or the DNR through the Land Management Bureau before you can submit it to the Register of Deeds.
So if you have all these documents, what do you do next?
Okay, you have to bring this to the Register of Deed together with the letter request for the subdivision, as well as the partition agreement between the parties.
So this assumes that you have a land. What if your property is not subdividable? For example, it's a condominium. You can't subdivide this condominium. What's your option?
Well, your option is either to ask your co-owner to buy you out, or you buy them out from that co-ownership, or better yet, sell it to third parties, and wherein the proceeds of that sale will be distributed among the heirs or among the co-owners.
Yes. Again, this presumes that the parties, the co-owners, are willing to settle amicably. But if one of the parties would not be willing to buy out or sell to a third party, then that's the time you also have to go to court.
Yes, so you will have to ask for the judicial intervention.
Okay, so let's discuss the judicial intervention.
Okay, for this kind of situation, the parties or any of the co-owner may bring a petition to the court, which is usually the regional trial court where the property is situated, and then detailing therein the nature of the case, the specific description of the land, the proof that the property is co-owned by them, tax declaration as well, because you need assessed value of the land for purposes of jurisdiction, because you still have to pay the docket fee or the filing fee for purposes of the court acquiring jurisdiction over your case. And then the parties will ask a relief to have the property in subject to be partitioned among themselves. So in partition proceedings, there are usually two phases. First one is for the court to determine whether there is indeed a co-ownership. And then the second one is for the distribution of the shares of each parties. In this second phase, it's usually the court encourages the parties to draft a partition agreement between themselves in order to define the portion on which they are going to get, or whether they are willing to sell it to somebody else. Otherwise, the court will have to appoint a commissioners in order to determine how the distribution will be.
I'm assuming appointing commissioners would be quite expensive to the
It is.
litigants.
It is.
Yeah, because you have to pay for the commissioners who are known in their field. If the court has appointed the commissioner, the three commissioners, then that would mean you have essentially no option to choose, because it would be the commissioners that will decide for you
Yes.
who will own what or what particular portion of the property
Yeah.
that needs to be subdivided. But I'm assuming during that period, there would be reasonable subdivision or even like easement when it's going to be landlocked.
Yes, the commissioner will take into consideration all the aspects or the situation of the property as well.
Yeah, because it can be difficult. Some may want to have the lot which is nearest to the road. They don't want to be at the back, right? Which is also one of the reasons why no partition is happening at the voluntary level. You need a third party to decide it for you, because these are contentious positions of the parties.
Yeah, and even or during the phase wherein the commissioner, because the commissioner will be going to the property itself to check on the location, the parties are actually notified, so they know the proceedings itself or what will happen.
Remember, we have one client who was forced to litigate because she is part of a co-ownership. Could you tell us more about that?
Yeah, that case, they're actually siblings. So the three of them are already outside or living outside the country, the Philippines, and one of the siblings is the one who's staying in that house and lot. So the three parties or the co-owners wanted the property to be sold already because they're getting old, and they wanted to have it monetized.
Yeah, and they're not enjoying the fruits of the property because a sibling is the one solely using it.
What we did there is we filed a judicial partition before the court and asking that the property be subdivided already or that it be sold to another person. So the court actually appointed already the commissioners in order to determine the distribution of the shares of each of the co-owners.
Is there a situation when a property may not be partitioned?
Yeah, if it is prohibited by law, or partition will render the thing unserviceable.
Or that there is a condition, for example, it's donated and the donor said you cannot partition this property until
Yes.
after certain number of years.
Yeah, usually 20 years. Or if the parties agree among themselves that the property will not be partitioned within a period of 10 years, which could be extendable for another 10 years.
So these conditions should be annotated in the mother title.
Yes.
So if you find yourself in a co-ownership situation and you still have not opted to do the partition extrajudicially or judicially, can you still sell or assign your interest in that co-ownership?
Yes, that happens. One of the co-owner would just sell his undivided share or portion in that property, and then the buyer will assume or be placed in the shoes of that co-owner. And then what happens to the title is that the agreement, or whether it be a deed of donation, deed of sale, or any other form of contract, will be annotated at the back of the mother title or the title itself, saying that he will be the new owner.
Yes, while you don't have a new title, you will still need to pay for the usual taxes. Capital
Yes.
gains tax, documentary stamp tax, transfers tax. Before the Registry of Deeds will allow you to have your document annotated. Okay, thank you, Attorney Wendy, for that information. We are now signing off. Bye!
Bye!